Hello and welcome to Fridays with Vistage. My name's Bill Black. I'm a Vistage member and the founder and host of the Exit Coach radio show, and I'm your moderator for today's session. Our presenter today is Hillel Presser, who is an MBA, author, attorney, president of the Presser Law Firm, and has been featured in major publications and written the 3 books you can see on your screen now. Here's something you'll love about Hillel. He's a Vistage speaker, so if you like what you hear today, tell your chair and he'll be happy to speak to your group. Mr. Presser is going to discuss different tactics of how you can minimize risk in your business, including the importance of separating business assets. Mr. Presser will discuss when it may be preferable to utilize international strategies and a look at how to utilize domestic and international together. Other topics will include how and when to use captive insurance companies, as well as other types of business insurance. So settle in for an interesting webinar. Hillel, I'll turn it over to you now.
I will apologize a little bit up front for my voice. I'm just recovering a little bit from being sick, so please bear with me. To start the presentation, I just want to give a little bit of a background information on asset protection. So what is asset protection? Asset protection is the legal process of titling one's personal and business assets to put them beyond the reach of future potential threats and creditors. So what we do is we help our clients protect any asset they have from any financial threat. It is our goal to make it so difficult, so expensive, if not impossible, for anybody to collect against you that they don't want to sue you in the first place. You don't want to be the low-hanging fruit. And a lot of people say, well, isn't that only for the ultra-wealthy? Do I have enough assets to protect? And the short answer is, the less you have, the more important the protection becomes. Our law firm has represented a lot of professional athletes, NFL, NBA players, and I always like to give the example of an NFL football player who signs for $50 million. Well, if they get sued for $5 million, they're not going to be happy, but they still have $45 million left. Contrast that with the everyday guy who saved up $500,000 over their career. If they get sued for $1 million, it's catastrophic. There's no coming back from it. And a lot of people say, well, what if I already have an asset protection plan? And if you do, it's fantastic. But understand that every single year, the laws change, so your plan needs to change. Also understand that there's a lot of misconceptions. In fact, probably one of the biggest misconceptions that I see when I speak are trusts. A lot of people will have a trust and they think they're protected, when in fact, most trusts don't give you any level of asset protection. Actually, they're really just a great estate planning tool. So why do you need asset protection? And I always show this cute little cartoon. It's 2 lawyers talking. One says, I say sue. The other one says, anyone in particular. And I always get a few smiles when I show this, but this is the reality, guys. Just like you're smart enough to get together as Vistage members to learn from each other once a month, the lawyers are getting together. But they're getting together once a week or once a day, and they're saying, who's our next target? There's over 100 million lawsuits every single year, and that number's growing. Think about it. In today's bad economy, people are losing their jobs. The people who are lucky enough to keep their jobs are making less and less. Why not go to any corner, hire an attorney for free on a contingency basis, and sue? Costs you nothing but 20 minutes of your time, and if you win, it's probably tax-free money. Lawsuits have unfortunately become the next biggest business. There's a 1 in 4 chance you'll be sued in the next 12 months, and the average person and business is sued 5 times over their lifetime. Now, these are just the stats. Depends, do you have 20 employees or 10,000 employees? Are you in the tech space? Are you in the security space? There's a 50% chance of divorce. When I give this presentation in Florida, where I'm from, I say there's a 99.9% chance of divorce. And a lawsuit can cost you tens of thousands of dollars even if you win the case. So unfortunately, they've made it so easy to sue anybody you want and make it free, because just go hire an attorney on a contingency fee basis, but so difficult and expensive to defend yourself. So the trick is not making money, it's keeping it. And the challenge I give to every Vistage member when I speak is, we're all used to growing our businesses. But for every 60 minutes you spend making money, let's stop and spend 60 seconds thinking about how to protect it. We don't want to be retired, backing out of our driveway, hit a bicyclist, and lose everything. So there's a lot of strategies. I want to talk to you quickly about the 4 basic strategies of asset protection. In the middle, we have exposed wealth, and that's anything that's in your personal name. So anything that's in your personal name is exposed, and you can lose it. If you have a checking, savings, stock, bond, brokerage, CD, money market account in your personal name, it's exposed, and you can lose it. If you have a piece of real estate in your personal name, it's exposed, and you can lose it. I have nothing in my personal name because I don't want to lose it. I work too hard. I don't want to do this again. So the key is, with asset protection, own nothing, control everything. Because if you own it, it's in your personal name and you can lose it. Own nothing, control everything. So what can we do? There's lots of different options. Number one is you can transfer your assets to a protective entity. And this is a pretty neat thing. Just like you and I are different people with different Social Security numbers, if I get sued, they can't come after you. If you get sued, they can't come after me. You and your protective entity are different people. You have a Social Security number. Your protective entity has a different tax ID. So instead of keeping your checking account in your personal name where it's exposed and you can lose it, transfer that checking account to a protective entity, maybe like a limited partnership, where now no one can touch it. If somebody sues you, you have a Social Security number, which is different than the tax ID of the protective entity, the limited partnership in this case, and they can't take anything. Instead of keeping a piece of real estate in your personal name where it's exposed and you can lose it, transfer the piece of real estate to a protective entity like an LLC. Now if someone sues you, they can't take the piece of real estate. So one strategy is to get assets out of your personal name where it's exposed and you can lose it and into the name of a protective entity. For example, a limited partnership for liquid assets, an LLC for real estate. Another strategy is to protect with liens. Property is power. What do you think a lawyer does before he sues you? He looks you up. He wants to know, are you a good candidate for a lawsuit? What assets do you have? I don't know about you, but when you look me up, I want to look poor. So there's a lot of ways you can put legal and enforceable mortgages and liens and encumbrances on your property. What's $1 million house worth if you own $950,000? What's a $100,000 Mercedes worth if you own $95,000? For anybody who's ever put money into their business, maybe you put $200,000 into your business for machinery or equipment or marketing or personnel or inventory, whatever it may be. Well, why not record a publicly recorded lien, mortgage, encumbrance on your business? Now, if the company or you get sued, you're first in line. Shouldn't you be the first creditor? There's different ways that you can put legal and enforceable liens and mortgages and encumbrances on your property. With your real estate, if you have a piece of property that's paid off, take out a mortgage. If you don't want to take out a mortgage, maybe consider getting a line of credit. It shows up as a mortgage when someone looks you up, but it doesn't cost you anything. Another thing you can do is you can convert your assets into exempt assets. And exempt assets just mean what assets are protected by state law. And if you go to our website, www.assetprotectionattorneys.com, there's a button there called Financial Planning Exemptions. And if you hit it, it'll tell you the exemptions for every single state in the country. But just to give you an example, in Florida, one of the exemptions is your homestead, your primary home. You can have a $10 million home, and if you get sued, nobody can touch it. In Florida, your retirement accounts are also protected. You can have $5 million in your retirement accounts, and no one can touch them. In Florida, your life insurance and annuities are protected. You can have $10 million in life insurance and annuities, and you can get sued, and nobody can touch them. So some of the great exemptions that are assets that are protected by state law in Florida are your primary house, your retirement accounts, your life insurance, and your annuities. Now, I know we're talking to people from all over the country, so again, if you want to see what's protected in your state, just simply go to the website, www.assetprotectionattorneys.com, click the button that says Financial Planning Exemptions, and we list every single state. A fourth method is to transfer all ownership rights. And this deals with who should own the shares in the corporations, who should own the membership interest in the LLC. Well, yeah, I understand if you put the property in the LLC, no one can take it, or if you put the liquid assets in the limited partnership, no one can take it. But what if you own the corporation? What if you own the LLC? Probably one of the biggest misconceptions I see with business owners is they own shares in an S Corp or a C Corp and an LLC. And if those business owners get sued personally for a car accident, slip and fall, breach of contract, whatever the issue may be, somebody can sue them personally, actually take the shares in their S Corp, C Corp, or membership interest in the LLC, and if they have a controlling share, now they can vote, which means they can hire, fire, liquidate the bank account, bankrupt the company, do anything they want. So what we want to do is we want to get all of those shares of the companies out of your name as well and into a protective entity. So I just want to very, very briefly just recap. You don't want anything in your personal name because that's exposed wealth and you can lose it. One strategy, take it out of your name where it's unprotected and exposed and put it into a protective entity, real estate in an LLC, money in a limited partnership. Another strategy is to protect with liens, find legal and ethical ways to put mortgages, encumbrances, UCCs on your property to make your assets valueless. It's called equity stripping. A third strategy is to convert into exempt assets, find out what's protected in your state, and purchase those type of assets. And lastly is to transfer all ownership rights. So get the shares of the corporations and the membership interests of the LLCs out of your name where they're unprotected. So I want to talk a little bit about separating business assets. And in general, you never want to have your business directly own any assets. You want to separate each asset associated with the business, and you want to have some sort of leasing strategy. And I want to break it down into two different categories. One being divisions and locations, and the others being actual assets. So first let's talk about divisions and locations. When I see people and I find out that they only have one company, it really bothers me because that means they're betting everything on one horse. If you're let's call it a manufacturer, and then you sell the products wholesale, retail, and online, that's four companies. One for wholesale, one for online, one for retail, and one for the inventory. If you have everything in one company and someone gets injured as a result of the wholesale product, well, you can lose everything. Why should you put all your eggs in one basket? No different if you're a builder and you do architect or design. That's three companies. One for the building, one for the architect, one for the design. If something goes wrong on the building site, why should your architect and design department suffer as well? So if you have different divisions of your business, if you have different locations of your business, it's really, really important that you have different companies for each division and location. Forget asset protection for a minute. Think about the financial literacy you're going to get. Now you'll have books for each location and each division. It's no extra work because you have the same amount of checks going in and out. You're just categorizing them in 2 or 3 or 4 different places instead of one. So now you're actually going to get to see which divisions and which locations stand on their own, which ones are profitable, which ones are not. Also, maybe you want to sell your business. Well, today it's either you sell your whole business or you don't sell any of your business. Well, if you separate your company by division and location, maybe the builder wants to sell the building division but not the architecture or the design division. Maybe the manufacturer wants to sell the retail division but not the wholesaler online. So it lets you sell part of your business or all of your business. Gives you a lot of leeway. Also, in regards to attracting talent, today it's, bring someone in, and if you really want to incentivize them, give them part of your company. But the problem is you either give them part of your entire company or none of your company. But let's say you bring the guy who used to run Google into your office. Well, why should you give him part of the retail or the wholesale or the manufacturing department? By breaking up your company into locations and divisions, you can give him just part of the online division, which is probably what he deserves. So one methodology is to separate your company by division and location. We want to do the same thing when it comes to assets. So I never like it when I meet somebody and they have all of their assets in their operating company. And the reason I don't like it is, think about it, not if, but when that company gets sued, if they have machinery, equipment, real estate, inventory, cash, accounts receivables, all of it inside of their operating business, well, when the operating business gets sued, it's going to lose everything and the business can't operate. So I don't like my clients to own any asset whatsoever in the operating business. Absolutely nothing. So, for example, take an example with a club that we worked with. We set up an operating company for the club. It owns nothing, just like your operating company should own nothing. We set up a separate company for the furniture that was worth $400,000. We set up a separate company for the stereo equipment that was worth $1 million. And we leased the stereo equipment, and we leased the furniture from those two separate companies to the operating business. Now, if the club gets sued, the club doesn't own anything. So all of a sudden, somebody gets in a fight, they fall back, they hit their head, and the club gets sued for negligence and overpouring. Well, the first line of defense is insurance. Hopefully insurance will cover it, and we'll talk about that in a later slide. And hopefully that's our first line of defense, and that's all we need to do. The second line of defense, if insurance won't cover it, is maybe we can use our asset protection plan to negotiate an inexpensive settlement, for 5 or 10 or 15 cents on the dollar. But worst case scenario, if insurance doesn't cover it and we can't negotiate an inexpensive settlement, well, what does the club have? The club has nothing. So the judgment against the club is worthless. We can close up the club and open up Club 2 the next day and lease the furniture and lease the stereo equipment from all of the holding companies for those assets. So another thing above and beyond separating your company by division and location is you want to look deep into your company and say, hey, what assets do I need to run this company? And then you want to strip those assets from your operating company, where you can lose them if the company gets sued, strip them out, put them in protective companies, and lease them back to the operating company. Your operating company should own no assets. So talking about insurance, people always say, isn't that what insurance is for? And, I love insurance, and I tell my clients to buy as much as you can because it's cheap and it helps you sleep at night. But understand something, insurance is a for-profit company. They're probably one of those profitable industries in the whole world. And that's because the majority of lawsuits are not covered by insurance. Anyone who's seen an insurance policy knows there's about a few pages of what's covered and about 50 pages of exclusions. And I think my father always said it best, which is, the big print giveth, the small print taketh away. What if your coverage is inadequate? Maybe you get sued for, $1 million, but you only have $500,000 in coverage. Well, maybe the insurance company pays the $500,000, but you have to come out of pocket the rest. Your insurance company might go bankrupt. If I would have said that 5 or 10 years ago, you'd kick me out of here. Today we have banks and Fortune 500 companies going out of business. Who's to say that the insurance companies won't be next? And also, insurance doesn't cover a lot of things like other uninsured financial risks and divorce. So the point here, guys, is that I love insurance. I think you should buy as much as you can. It's cheap and it helps you sleep at night. But understand that insurance alone is not the answer. You need your own asset protection plan to supplement your insurance. I call it simply the belt and suspenders approach. You want to put as many layers and firewalls in between your creditors and your assets as possible to force them to settle for pennies on the dollar. So I want to talk about captive insurance real quick, and I just want to, talk about it generally, and then we'll go through all the slides. For some reason, people are just now starting to talk about captive insurance, but it's been around forever. I mean, captive insurance companies have been around for probably 60 to 70 years, maybe more, and probably about 85% of Fortune 500 companies use captive insurance companies. And all captive insurance companies are insurance companies that are owned by the client. So you would own the insurance company. Now, what's the great thing about insurance? The great thing is if we have a claim, hopefully they pay, and any, obviously, check or premium we write to the insurance is tax deductible. What's the bad thing about insurance? Well, if they don't pay our claim, it puts us in a really, really bad position. And what if we pay our premiums for 10 years, we have no claims, we've lost all our money? So by having a captive insurance company, by owning your own insurance company, it takes all the disadvantages away and gives you all the advantages. You know if you have a claim that the company's going to pay because it's your company. And if you pay the company for insurance for 10 years and you have no claims, well, it's all going to be profit to you because you own the insurance company. So it's really just a form of self-insurance. And captive insurance companies are used to write insurance policies for businesses that, maybe they can't get that type of coverage on the open market. Maybe it's too difficult or expensive to get that type of coverage on the open market. So essentially, third-party actuaries, third-party underwriters, they come into the business and they interview the owners, they interview the key employees, they look at all the tax returns, and they're looking for what type of insurance does this business need, that might be low probability, that might not appear on the open market. If it does, it might be too expensive on the open market. And the captive insurance company uses its insurance to write those type of policies. So, for example, captive insurance company might write a policy to a doctor, and I'm just making this up, for loss of hospital privileges. What are the chances that the doctor loses his hospital privileges? But if he does, it's catastrophic. That's coverage that you probably can't buy on the open market, and if you did, would probably be cost prohibitive. Another type of coverage might be reputational harm. Maybe you work in a small town. Well, God forbid something happens, you never work again. But you can't buy that type of coverage on the open market. Maybe it's loss of key customer, loss of referral source, technology malfunction. It's literally customizable insurance. Now, of course, it's got to be legal. It's got to be ethical. You can't just, make up numbers and make up insurance policies. Very, very highly scrutinized by the IRS. But nevertheless, really, really good for a company that continuously grosses and nets big numbers and has insurance needs. So let's take an example. You have a company that's grossing $20 million, and they have $18 million in expenses, and they have a net of $2 million. Well, maybe the captive insurance company can be used to write insurance, and let's say that the actuaries and underwriters say that you can write, $800,000 of insurance. Well, now instead of having a $2 million net, there's a net of $1.2 million, which means you've literally saved taxes on $800,000 year one. That $800,000, of course, goes out of the business and into the captive insurance company to pay the premiums. However, the insurance company does not pay tax on that money when it comes in because under IRS Code 831 subsection B, the captive insurance company doesn't pay taxes as long as that money is under $1.2 million, and they've been talking about even upping it to $2 million. So year one, you have a tax deduction from the operating business standpoint. Year one, the captive insurance company does not have to pay taxes, and year one, you're getting great customizable insurance. Now, the reason I talk about it has nothing to do with taxes. The only reason I like captive insurance companies is from an asset protection point of view, and look what we did. The captive insurance company gave us the ability to pull $800,000 out year one from the operating company where it was unprotected and exposed and put it into the captive insurance company, which is a form of a protective entity, and we can protect that. So I love it from an asset protection point of view. So people always say, well, if it's too good to be true, isn't it? And usually it is. Year one, you have tax deduction. Year one, you don't pay taxes on the money that goes to the captive. Year one, you have insurance. Year one, you have asset protection. What's the catch? The catch is, of course, you're going to pay taxes. You can take the money out of the captive anytime you want as ordinary income, which means essentially you've deferred your income. If you need a loan and it's a real legitimate loan, you can take the money out as a loan. Maybe you need a piece of machinery for $500,000. Well, instead of going to a regular bank or loan company and getting a mortgage for 7%, a jumbo mortgage rate, maybe you take a loan from your captive, a short, a long-term AFR, a 2, 3, 4%. And what do you care what the percent is? Because you're paying yourself. It's called being your own bank. Now, again, guys, this has to be totally, totally legal and ethical. That means it's got to be a real loan, memorialized in writing, real interest rates, real payments, real balloon. You can't just make up terms and think it's going to fly. Again, highly, highly scrutinized by the IRS. But for a company that continuously grosses and nets, big numbers, this is the end-all, be-all. And I love it from an asset protection point of view. To get a little bit more specific, you can have the captives either domestic or international. That just means the license. Most clients choose to have it international just because it's cheaper to set up and maintain, and there's less capitalization requirements than normally. However, you can have it set up domestically. In fact, we just set one up, I think, not too long ago in North Carolina. And, I put here that, closely held businesses, doctors, lawyers can benefit from captive, but really it's any business owner or business owners. Regardless of what the business is, if you have those gross numbers, if you have the net numbers, if you have the cash flow, and you have the insurability, it's a no-brainer. There's no better thing. With that being said, I keep talking about how the IRS, really strictly scrutinizes these things, and you got to make sure that you follow the formalities. obviously operate it like a normal insurance company, and you don't have to do that yourself. There's things out there called captive management companies which actually do that for you. Of course, the proper risk distribution must be present, and obviously depending on the jurisdiction, domestic or international, and what state or country you're in, there's different investment of initial capital required. But it's always really, really important that you follow these corporate formalities. Otherwise, the IRS can disallow, all the deductions, and you would have spent a lot of time and money for absolutely nothing. So like anything, you want to make sure you do it legally. Like anything, you want to make sure that you do it ethically. And we talked about, taking the money out. You can take it out, as deferred income, as ordinary income. You can take it out as a loan. But I just wanted to also touch on liquidation. The captive is treated like a C Corp. So if and when you go to liquidate or close the captive, you're going to pay, essentially long-term cap gains. Okay? So I want to touch on international asset protection just because I think it's really, really important, and it's getting more and more popular these days. And that just means asset protection outside of the United States. And, really the first question I always get asked is, when does someone need international asset protection? And, there's no right or wrong answer. I have clients who literally only have a couple $100,000, and they spend big time setting up international asset protection entities. I don't think it's needed, but they do. On the other hand, I have clients that have millions of dollars, and maybe they're in their late 80s. They don't work, don't drive, don't own real estate, don't own businesses. They have very low liability. What I tell my clients is, if you have over $1 million in liquid assets, you should at least become educated and consider some sort of international asset protection entity. Doesn't mean you have to do it, but you should consider it. And there's a lot of different types of international entities. There's the International LLC. There's the International Trust. You can, of course, have the International Captive Insurance Company. There's something called a dual hybrid trust, which is a special trust that we do, which it's kind of the best of both worlds. For the people who really don't have the comfort level with international, the hybrid trust is a trust that can essentially start domestically and end up internationally, if need be. So just to tell you how international protection works, I'm putting all these things on the screen, but rather than go through them, I'm just going to give you an example of, what you'd have to do if you'd want to come after one of my clients who has properly and proactively, set up some sort of international asset protection strategy. First thing you'd have to do is sue them and beat them in the U.S. And the reason for that is because in most cases, unless there's a judgment against you, unless it's a special punitive damage case, a lot of times you don't even have to disclose what assets you have. So let's say someone takes 5 years and they sue you and they beat you for $5 million. Well, the next thing they need to do is they need to sit you down for a deposition under oath. And they need to know the right questions to ask, which very few people know because there's very few international asset protection attorneys in the country. To give you an idea, we might compete with 5 or 10 guys who get the majority of the work throughout the entire country. But let's say the creditor who sued you and won a $5 million judgment hires the best lawyer, and he knows exactly what to ask you, and he says, do you have any international asset protection entities? And your answer, of course, will be yes, because asset protection is not about hiding or secrecy, and you never want to perjure yourself. And let's say, for the sake of the example, you set up a international trust in the Cook Islands. I don't know if anyone's been there, but the last time I checked, there's one flight. I think it left Sunday night from California. It was a 14-hour flight through New Zealand. The Cook Islands are in the middle of the Pacific Ocean, and you're stuck there for a week. So very hard to get to. Once people get there, they find out that everything they did in the U.S. means nothing because their U.S. judgment is not upheld in the Cook Islands because the Cook Islands don't enforce U.S. judgments. So now they must relitigate their case. Well, in order to relitigate their case, they need an attorney. The problem is there's not that many attorneys in the Cook Islands, and they may or may not be conflicted off the case. So they might now need to fly to the nearest country, let's just say New Zealand, to hire an attorney there. Well, unlike the U.S. where it's very easy to hire an attorney because they work off contingency fees, a lot of these countries do not work off contingency fees. So now you're paying your U.S. attorney hourly, your New Zealand attorney hourly to fly back and forth to the Cook Islands. Well, now you have all of your attorneys back in the Cook Islands, and you say, I'm ready to sue. The problem is depending on what country we use, there's a very short statute of limitation, which means you probably have somewhere between 0 years and 2 years to sue. And I don't know many cases in the U.S. that take less than 2 years. So automatically you're barred, you have to go home. If it's within the statute of limitations, I'm going to argue that you have to post a bond, because if you lose, you have to pay our attorney's fees. In fact, I believe it's with the Belize LLC, you have to post half the amount. So if you're suing for $5 million, you have to post $2.5 million with the court as a bond just to have the privilege of suing, because if you lose, you have to pay the other side's attorney's fees. On top of posting the bond, the level of proof is much higher. So in the U.S., while it might be 51%, outside of the U.S. in some of these asset protection jurisdictions, it's beyond a reasonable doubt, 99.9%. You would need more proof to collect my client's funds than they had to put Casey Anthony in jail for murder. Normally, there's no punitive damages, so if it's a car accident, you may or may not have to pay to fix the car, but certainly you won't have to pay for the big pain and suffering. And any good asset protection attorney in your 50 or 100 or 150-page customized trust agreement will put what's called a Cuba or a flee clause, which allows you to relocate the trust assets at any time. So while someone's suing you in the Cook Islands, you can move everything, not you but your trustee, to Belize or to Switzerland or Nevis or Liechtenstein and somewhere else. I wanted to keep things simple today with one example, but a lot of times when I personally set up an international asset protection entity for a client, I might register it in 2 to 3 different countries just to make it that much more difficult for any potential creditor to go after. So international asset protection entities, in this case we gave the example of a trust, very, very difficult, very, very expensive to go after. I think last time I checked, the stats were something like less than 1% of all of these entities were challenged. Not beaten, but challenged. So for someone who has a lot of liquid assets, the international asset protection entities make a lot of sense. Another good time to use them is if you sell your business. Probably one of the biggest lawsuits I see is I'll have a client, and he's the business owner or partial owner, and he sells his business. Well, we already know what happens. You know, nobody will ever run that business like you. Nobody will ever keep the income as high as you had it. No one will ever keep the expenses as low as you had it. And what they do is they come in and income goes down, expenses go up, and 2 to 3 years later, they've ran the company to the ground, and they turn around and they sue the owner for fraud. I call it renegotiation. So anytime you have a liquidation event, an inheritance, a sale of a business, whatever it may be, I definitely recommend that's a good time to consider international asset protection as well. And, I also just wanted to really briefly talk to you about how the domestic and international fit together, okay? It doesn't mean you have to go domestic or you have to go international. A lot of times a client will want to do a hybrid of both. They want to get the best out of the domestic asset protection, which, might give them 80 to 90% protection, but still lets them retain, a lot of control. Others, want to have the international asset protection, which, you do lose a bit of control, but I'll never say you're 100% protected, but, you're as close to that 100% as possible, maybe 99.9%. So some really nice strategies where you can kind of layer the protection and intertwine them is, number one, we talked about the hybrid trust. There's really, really specific trusts we can set up that start off domestically, however, have the right asset protection and the right anti-creditor language inside of them, where if triggering events happen, that domestic trust can become an international trust. So I call it a hybrid trust or a sprinting trust. Really, really interesting for people who just, for whatever reason, don't have the comfort level with the international asset protection. Another thing you can do is you can simply hook up the international structure to your domestic structure. So, for example, we talked about maybe how a limited partnership might own your liquid assets. Well, maybe that's layer number one, and because it's domestic, it gives you 80, 85, 90% protection. Well, in order to get some more protection, in order to have that safety net, maybe what we do is we take the international trust, we have it own, be the limited partner of the limited partnership, and now you have the best of both worlds. Everything's domestic where you don't lose that much control and you may or may not have a better comfort level. So you have that 80, 85, 90% protection. However, if things ever hit the fan, you have the safety net. And because the limited partnership is legally and ethically and properly owned by the international trust, the limited partnership can simply send money to its rightful owner, being the international trust. So it's not always, one or the other. A lot of times, you can layer and firewall and commingle both the domestic, and the international asset protection entities. So that's all we have for today. I think at this point we're going to turn it over back to the moderator for questions. And certainly any questions you have, feel free to type and send them in. I think we've gotten a bunch so far, but I'm more than happy to answer any and all questions that I can for you and do anything I can to help you. Also, today was just meant to be a very, very short presentation, of what asset protection is, why you need it, why it's so important, why liability insurance simply isn't enough, a couple strategies of how to protect your assets, how the captive insurance company fits in, and certainly how international asset protection fits in. If anybody would like to go into more depth and detail, please feel free to contact my office. The information's there. I'm happy to speak to you complimentary. We have 9 attorneys, but I'm happy to speak to you directly at no charge, have a complimentary preliminary consultation. And as they said earlier, I do speak to Vistage groups across the country. So if you like what you heard and you'd like, a much longer presentation, feel free just to let your Vistage chair know. They can get in contact with me, and I'd be more than happy to do anything and everything I can to come speak to your group and go above and beyond. So again, thank you so much for listening. And at this point, I would encourage you to continue to submit your questions. And I would also encourage you to stick around because I know we've already gotten some good questions in. And I think I'll turn it back over to the moderator to go from here.
Thank you, Hillel. Great information, well presented. We do have several questions. Just a reminder, if you have questions, type them into the Q&A box at the lower right of your screen. The first question, Hillel, is who should be the trustee of my International Asset Protection Trust?
Great question. So the reason why the International Trust gets so much protection is because it's international, which means it's outside of the U.S. court jurisdiction. So right away, you would never want to have any U.S. individual be the international trustee. If you have someone international who doesn't have any U.S. ties, that is someone who might be able to be the international trustee. However, normally what people do is they use a international trust company. So there's a lot of international trust companies. They're set up only and solely to be the trustees for international trusts. That's what they do as a business. That's what they do as a living. So most of the times we'll find, a qualified and reputable international trust company to serve as the trustee that, of course, the client feels comfortable with. Now, when you do that, of course, you do lose a little bit of control because, they make the decisions. But there's a lot of checks and balances that we can put into play. We can have the client appoint what's called a protector who can watch over the trustee. So, for example, they could fire the trustee if they don't like them and appoint someone else. We could put clauses in the trust that say, hey, listen, anything over $5,000, the trustee can't do without the protector's signature. Also, we always want to use third parties. So we want to have a third-party trustee, a third-party protector. We'd want to custody the funds somewhere third party. So you want to make sure that you put the checks and balances into play.
Makes a lot of sense. Another question we have here is, can I transfer my real estate and other immovable assets to my international trust?
Another really good question, and let me give you the legal answer, and let me give you my advice. Can you do it legally? Yes. Do I recommend it? No, and here's why. There are some attorneys that tell you to do it, but to be honest with you, I think it's a waste of money. I think it's false protection, and here's why. Let's say you take a piece of property that you have in Fort Lauderdale, Florida, and you transfer it to your international trust. Well, you might be able to say, it's protected, I don't own it, it's owned by my international trust. But at the end of the day, you can't pick up the property and fly it to the Cook Islands or Nevis or Belize. The property is always going to remain in Fort Lauderdale, Florida. So if I'm a Fort Lauderdale, Florida judge, I can easily say, I don't care who you claim owns the asset. The property is located in my jurisdiction, and I'm going to rule on it. So I do not like using international entities, for immovable assets. I actually much prefer, in that case, to use a domestic structure. So, for example, in a case like that, maybe what we would do is we would take the property in Fort Lauderdale, Florida, put it in an LLC. Maybe we would have that LLC owned by a limited partnership. So, we put together a couple layers of domestic asset protection, And I think that you actually have a lot better chance of a domestic U.S. judge following the domestic law, because why would he or she not follow it, versus following the law of a land where they don't reside or have jurisdiction. So can you do it? Yes, but I strongly recommend against it.
Hillel, does the international trust apply to family trusts too, for instance, for family assets?
Sure. So the question confuses me a little, but I'll do the best I can to answer it. A trust could be no different from a family trust. Lawyers give trusts and companies all sorts of sexy names, but really probably 80 or 90% of the bones are the same. So, for example, you can have a limited partnership or you can have a family limited partnership. The only real difference is, one you're calling a limited partnership and the other you're calling a family limited partnership because it probably has family members involved, maybe spouses or children or relatives. So I don't see that there's any big difference between a quote-unquote international trust or a quote-unquote family trust. But the answer is any trust can be international. And it's not just for asset protection. When we create these trusts, whether we create an international trust or an international entity or a domestic entity, we're looking at everything, of course, up front from an asset protection point of view, but also from an estate planning point of view, also from an income tax planning point of view, also from an estate tax planning point of view, also from a business succession planning point of view. So the key is that you want to make sure your financial team is talking. You don't want everybody alone on their islands, and you want to make sure that everything intertwines. So, for example, if a client comes to me and has a domestic trust, well, maybe what we do is we make one of the beneficiaries of the international trust the domestic trust. And this way, if the client dies and happens to have money internationally, well, it flows right to his domestic trust and goes wherever he wants it to go. So really, really important that you take that asset protection and you combine it with the estate planning.
Hillel, a lot of Vistage member business owners are contemplating the day when they sell their business and turn them into liquid assets. What type of planning should they be doing in advance so that they're not sitting ducks when they are all in cash?
Sure. So again, it's obviously going to depend on how much they sell for. If they sell for $200,000, $300,000, $400,000, $500,000, which I'm assuming would not be the case, a domestic entity would do fine, like a domestic asset protection limited partnership. That'll give them 80, 85, 90% protection. They're not expensive to set up and maintain, not expensive at all. Someone liquidates for multi-millions of dollars, he definitely wants to set up an international asset protection trust, because that's when you take the chips off the table. That's when you want to have that most protection. Maybe 80, 85, 90% is not enough, and you want to have not 100, but let's call it 99, 99.999, as close to 100 as possible. But the key is the first thing you have to do is, inventory all your assets. So when a client comes in, we go over everything, and we go through a pretty comprehensive planning process, because the client always has a lot more than they think they do. Once we go through all that, we can literally blueprint every single asset. I don't care if there's 15 or 20 assets, from the shares in the business to the cash and accounts receivables in the business, to the primary real estate home, to money owed by a brother, to, arts and antiques. We want to literally blueprint every single plan, and then it's not all or nothing. What a client normally does is they'll say, okay, what are the most important things to me? It's the shares in my business and it's the liquid assets. Well, okay, great. Let's protect those today. And 6 months down the line, let's go to stage 2. What's the next most important? So really important to inventory what you have, really important to put a full architectural plan into place, and then you just break things up in stages and strategies, whatever is most important to the client. I spoke to a client this morning, and, he wanted to protect the shares in 2 C Corps. One was an operating company, one was an intellectual property company, and we didn't even talk about his personal assets. Now, when we go through his comprehensive planning process, we'll talk about his personal assets, we'll architect how to protect every one. We just won't start there because that wasn't most important to him.
Makes a tremendous amount of sense. So let's move to captives for a second. We have a couple questions there. How long should I intend on keeping my captive open? For instance, what if I retire?
Sure. So, the longer you keep them open, the more benefit you're going to get and the more financial sense they're going to make. They're not inexpensive to set up, and they take a lot of time to set up. So certainly it's not the type of entity that you're going to set up 1 year and close, a year later. Absolutely not. I would say that a minimum that someone should consider opening up a captive is if they're going to keep it open for, let's call it on the low end, maybe 3 years, 3 to 5 years. But, the captive is a great, great solution, but it is a long-term solution. It's a lot of work and a lot of money to do for 1 year. I'm not going to say that you won't have a net benefit, but, is the juice really worth the squeeze? I think 3 to 5 years is a pretty decent timeline to judge by.
Okay, and the other question is, what amount should I be willing to capitalize my captive with?
It really depends, and it depends where you set your captive up, where it's licensed. Is it domiciled international? Is it domiciled domestically? I'd say to give some sort of range, and I know it's a big range, I'd say on the low end of probably around $50,000. On the high end, could be $300,000-$400,000. Again, every country and every state, the different jurisdictions have different capitalization requirements. But I think if you use $50,000 on the low end to $300,000 or $400,000 on the high end, I think that gives some sort of guidelines.
Excellent. Well, that concludes our questions. Do you have any final comments for us today, Hillel?
No, I think it can be overwhelming. People work their whole life, and, it's a lot to do at once. Obviously, it's a lot easier if when you start a business, you do it correctly. When you buy a piece of real estate, you do it correctly. The best advice I can give is just don't get overwhelmed. Asset protection is not an all or nothing, type of practice. We all work so hard, whether it's because we want to retire early, live a better life, give our kids the things we didn't have, donate to a favorite charity. And, unfortunately, lawsuits have become the next biggest business. And, one lawsuit that we can't even control can wipe away every single thing that we have. You can have a son or daughter driving your car, and you get sued for everything and lose everything because the car is titled to your name. So the lawsuit that you lose everything on might not even have anything to do with you. So probably the best advice I can give you is the challenge, which is, for every 60 minutes you spend making money, stop and spend 60 seconds thinking about how to protect it. And again, don't get overwhelmed. If you do one thing to protect the liquid assets, if you do one thing to protect the real estate, anything we can do is better than nothing. So it's not all or nothing.
Terrific information. Thanks so much for joining us today, Hillel.
Thank you so much for having me.
And as you can see, there are several ways to get in touch with Hillel and his firm on your screen right now. And I want to remind you that upcoming Vistage webinars include Friday, August 26th at 10 a.m. Pacific Time, Improve Your Sales Team's Health and Performance with Mike Zani and Greg Barnett. And on Friday, September 9th, 2016 at 10 a.m. Pacific Time, How to Get the Right Financial Reports for Your Business with Dennis Najjar. So please join us for those upcoming Fridays with Vistage webinars. And thank you for joining today. This concludes the webinar.